This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Judge Kathy C. Bell, who we were literally just talking about in one of the Leibowitz discussions, has denied the motion to quash from J.W. Apostate and allowed the subpoena by Watchtower Bible and Tract Society to go to YouTube for J.W. Apostate's identity. Judge C. Bell writes, having heard further from the parties, I deny the motion to quash. Watchtower has provided an explanation as to why it has not pursued more cases, as well as evidence that the alleged infringement would not constitute fair use because the videos are full length and not accompanied by criticism. That there may be criticisms in the comments section does not render the initial postings fair use. Movement argues that the subpoena is unenforceable because the videos were all taken down before Google received notice. I am dubious because this allegation contradicts what Movement alleges elsewhere, that the videos were taken down only after the notices were received, and because in Watchtower's initial declaration it attached a letter it sent to Google asking it to take down the videos. But the subpoena would be unenforceable if the material had been taken down before the notices were received, so Watchtower's counsel should provide Google with a copy of this text order, and Google is advised that compliance with the subpoena is not required if, in fact, the videos were taken down before Google received any notice of the possible infringement. Finally, some free advice for Movement: inflammatory, vulgar, and abusive language in court filings is not a good idea. Hereby ordered by Judge Kathy C. Bell, May 9th, 2020. So that is the end, unless there's an appeal, I guess, or motion to reconsider or something. That is the end of the Watchtower Bible and Tract Society versus J.W. Apostate DMCA subpoena. They will now get whatever identifying information YouTube has on J.W. Apostate's account. Maybe that also includes the Google account associated, because I think you have to have a Google account. So if there's any identifying information in there, then it'll go to Watchtower. If there's not, or if it's just gibberish, Watchtower will get gibberish or nothing, and that will be the end of that. We'll see what happens there. But before the judge issued this order, J.W. Apostate did file one last thing, and I don't think we've gone over this, right, Tech?
I don't think so.
So this is what J.W. Apostate filed. This is what J.W. Apostate sent to us. And then I think the actual document appeared on the court docket. And so now J.W. Apostate is talking about 61 DMCA subpoenas or 61 court proceedings, and all of them being filed over excessive concerns about prestige and material pursuits, and about defending what they feel are their rights via all of these completely bogus DMCA subpoena legal actions. And then this goes on for 155 pages. Let's see if there's anything really in here that's new. He lists all of the other subpoenas and then points out that the Truth and Transparency lawsuit that Watchtower sent or filed doesn't have a DMCA subpoena. So how could that be their justification for using DMCA subpoenas if their copyright suit that they were eventually going to bring using DMCA subpoenas didn't actually have anything to do with a DMCA subpoena? This has all been nothing but judicial doxing and a religious witch hunt for moles, apostates, and whistleblowers. That's his highlighting, or their highlighting, not mine. Importantly, the court viewed fair use not as a valid excuse to otherwise infringing content, but rather as not infringement in the first place. Oh, so they cite to Lentz v. Universal. And yeah, that's a fair use case. That there was transformation there. That's why there was a transformation and no market usurpation and no outright copying in Lentz v. Universal. So J.W. Apostate files more and more and more about the Watchtower Bible and Tract Society. They say Watchtower ignored the court's authority and simply refused to produce documents. The judge awarded $13.5 million in favor of Lopez in the Lopez v. Watchtower Bible and Tract Society case, in which the plaintiff brought a negligent hiring and retention lawsuit. There was another one, JW versus Watchtower Bible and Tract Society. A Riverside Superior Court of California awarded the plaintiff, JW, a judgment of $4 million plus interest because it refused to obey the court's order to produce files about a criminal within the JW organization. So he's pointing out other awards against Watchtower. None of this really matters for a DMCA subpoena, and JW Apostate seems to be asking the judge to open an investigation into the other subpoenas, many of which were granted by the same judge.
I believe one of the arguments that they're trying to make is that the Watchtower Association is not going into this with clean hands. They're not going into this with a respect for the law or the court or as an institution, that when the court orders them to do things, they would rather pay millions of dollars than comply. And so now they're asking other companies to comply with their DMCA subpoenas so that they can then do what they do with that information.
Yeah, and it's a valid argument as to your one subpoena, but I don't think it's a valid argument as to all the others. And that's exactly what it appears JW Apostate has done. They have responded in the Truth and Transparency lawsuit. JW Apostate, as far as we know, is not Truth and Transparency, is not Brian McKnight, Ethan Dodge, or faithleaks.org. But this John Jane Doe, who we think is JW Apostate, do we know? How do we know?
Because JW Apostate sent it to me.
Okay, so they claimed. Yeah. Okay.
Yeah, they claim.
Oh, and look, it's the same kind of thing. Look at this introduction here compared to this introduction here. I mean, I'm not saying that you couldn't get the same effect here with the same program or something, but
we now have a table of contents, so we're upping the game.
Table of contents, a table of authorities. No purposeful availment, no minimum contacts, harming a company in the forum state does not constitute. So this is going to be an argument about jurisdiction. Those are all jurisdictional arguments. Purposeful availment is a way that a state can have jurisdiction over you, even if you don't live in that state. Minimum contacts, same thing. Harming someone in the forum state, minimum contacts for personal jurisdiction, whether it's fair play and substantial justice. Those are literally the elements of jurisdiction. JW Apostate apparently argues that the Watchtower Bible and Tract Society is aggravated and butthurt. I'm not even sure what to do with that legal language. As an example of aggravated butthurt. Interesting. Maybe we'll make that our title, aggravated butthurt. So again, goes into how this is an attempt to silence free speech. I personally disagree that posting an organization's internal videos or content is free speech. I personally do not agree with the Jehovah's Witness practices, but that doesn't mean that I think they shouldn't have the same rights as everybody else to their copyrights, and that we should just let it be open season on Jehovah's Witness intellectual property. Certainly, if there is a criminal activity going on, there needs to be an investigation, but JW Apostate is not the investigator in charge of that investigation and does not have prosecution authority that any of us know of. So that's why you have to choose prosecutors and stand behind their decisions and throw them out or elect new ones or appoint new ones if they're not doing their job. These arguments are going to be a lot of the same arguments, and I'm not going to go over them individually. John Jane Doe would argue that the alleged copying of the whole videos is necessary for criticism. Okay, so saying that the posting of an entire video can be enough for criticism. There's case law surrounding that, and you likely have to be highly transformative in order to use the entire work and still be a fair use.
So if I could summarize what JW Apostate is arguing, because I've read all of this. So they say that by posting everything on a whistleblowing site, that is criticism per se because of the forum that is posted in and the audience that it is posted to. And that they have to show the whole thing, or else Watchtower can claim that it's being taken out of context or that it's cherry-picked. As well, if you provide the whole thing, then other people can also make use of it. Versus, say, the original poster just wanted to provide 3 points of criticism, then if they only use as much as is necessary, other commentators and analysts or whatever would not have access to the full document, right? So there's a couple arguments in there, and I was wondering what your thoughts were on those.
It should be. It's a very good argument for criticism. It's the argument that I would go with primarily, but I would do it from truth and transparency from the defendants. And the judge will not entertain this filing from JW Apostate they're not a party. They don't have what we would call privity. They're not a party. They don't have the standing or right or privity to be a participant in the case. There is a way to get standing as an amici, as a friend of the court. You can follow the court's procedure to request permission to follow an amicus brief, but none of that, I don't think any of that was done here, nor do I think the judge would really grant that, as the case was just filed, and this isn't something where there's an important judgment to be made, and the judge needs help from friends of the court to help make the proper legal arguments. So another argument is that it has to be posted in full, because even if the original poster offers several points of criticism, if they just use the minimum amount, then there's not the extra information available for other people to make a fair use of it, for other people to offer their commentary and criticism. Again, this is the whole that's
idea.
That's sort of a secondary fair use. Like, it's my fair use is posting it for you to make a fair use, is not the way fair use law is written. So posting it on a critical website, you could argue that that's criticism, and that's a fair use. That's transforming it into a different purpose, and it probably is transforming it into a different purpose. And that's a great fair use argument, and that worked partially in the Sargon of Akkad case, partially in the Dark Spilver case. We saw that, where posting it on an XJW forum on Reddit was for criticism and commentary. Make those arguments, like fully flesh out those arguments, possibly hire an attorney to make those arguments after conducting legal research. I don't see any of that being done here, and that's what I'm concerned about. Sure, truth and transparency's lawyers should be investigating jurisdiction and whether they can go to, the Southern District of New York to get jurisdiction over wherever truth and transparency is located, which I think is in Utah or something, at least according to JW Apostate here in this filing.
And I suppose the last thing is that you need to release the entire unedited thing, because if you only release little bits of it, then people can say, oh, it's cherry picked. Oh, it's taken out of context. Oh, it's, it didn't mean that in the broader sense. And so in order to avoid the criticism that you've misconstrued what's happened, you need the whole thing.
That sounds like a practicality, but it sounds like a consequence of making a fair use. If you didn't have fair use, you wouldn't be able to make any use. So you do have fair use, so you have to make a use that uses the minimum amount necessary to make your transformation and make your point, and no more. And so if you do that and somebody accuses you of cherry picking, oh well, I don't think you gain the right to use more than what's necessary for a fair use, because then you would have a hard time explaining yourself. That's not part of fair use law. But yeah, I can see the arguments. You definitely maybe tell the judge that, like, hey, we have to post this here because we want to make a fair use and have a whole community contribute criticism and commentary and everything. I think those are the best arguments. First, like, truth and transparency, the defendants have to make those arguments. And two, those aren't necessarily winning arguments. The best arguments are these jurisdictional ones. If truth and transparency really isn't a business that has any contact with New York, then yeah, make all the jurisdictional arguments, and then Watchtower has to go after you in your home state. On the other hand, maybe Watchtower is looking for a settlement of some kind or something. I'm not sure that moving the case to Utah wins anything. Case just has to move to Utah, and then Watchtower will continue the case. But maybe they're discouraged. Why would Watchtower be discouraged by moving the case to you? I don't think so. I don't think Watchtower is going to have any problem prosecuting the case in Utah.
One of the things that was brought up in the supporting cases for why Southern District of New York is bad forum was that if none of the witnesses or none of the lawyers and the supporting documents and everything, like if none of that is related to Southern District of New York, then it's an extra burden on the defendants to move everything to a new state and to send everybody over there for depositions, versus if the plaintiff just sues in the correct jurisdiction, then it becomes easier for the defendants to handle the burden of litigation.
Well, I think the defendants are from Utah, or at least one of them is, so it would be convenient for the defendant to have their court case in their own backyard. So I don't know that they've gotten established in New York. The argument would be that if they already are like 3/4 of the way through the court case and then want to move it, that's a burden on defendant. But if you're at the beginning of a court case that was just filed and your first thing you're going to do is a motion to dismiss for lack of subject matter or personal jurisdiction, in this case, personal jurisdiction, then I think that's exactly the time when you move it. All right, so that's the status of the JW Apostate matter. Apparently, JW Apostate is very upset that there are other Jehovah's Witnesses, Watchtower, Bible and Tract Society lawsuits out there. JW Apostate has inserted themselves into the Truth and Transparency lawsuit, trying to make a jurisdiction argument that should be best left to Truth and Transparency to make for themselves. We'll follow it all and see what happens. If there's anything further to update in the JW Apostate subpoena matter with YouTube, we'll do that too. Otherwise, everything's done there, and it's going to happen behind the scenes. And if there's a future lawsuit against JW Apostate, we'll have to just catch it as one coming from the Watchtower Bible and Tract Society. So let us know what you think in the comments below. Kind of a disappointing end. I mean, I didn't, not unexpected end, but disappointing. We wanted to see the subpoena more highly scrutinized. But the subpoena was scrutinized. Judge Seibel did give the subpoena and the opposition the time of day and did seem to treat them fairly. So my post-mortem is that this is the correct outcome for the JW Apostate DMCA subpoena to YouTube. I don't like it, but I think it's the correct outcome. Let us know what you think in the comments below. So that is our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube. Thank you very much to our supporters. This is a community-supported channel, and we would not exist without your monthly financial support on patreon.com/ljfrench and sponsors.com/law. Thank you very much to our $50 plus supporters in the month of May. This is a really long list. I love it. Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And thank you to the $5 plus supporters scrolling on the LED matrix beside me. I'll see you in the videos that drop. Bye.